Hi, Evan Nielsen here from Nielsen Law Group. The subject in this segment is the tax ramifications of a short sale, specifically in a bankruptcy. So the setting would be, for whatever reason, a bankruptcy determined that it's the right thing for you. You have property that you don't intend to retain in the bankruptcy, and so instead of just letting it foreclose, you're going to conduct a short sale. Now, there are obviously many reasons why you would want to do that, primarily taking control of the transaction and making sure that it isn't in your name for an indefinite period of time. But whatever the reasons are, when you pursue a short sale, that means that the amount of revenue that the bank or whoever will receive in the transaction is going to be less than the amount of the debt on the property. So that means that there's going to be some forgiven debt. And forgiven debt always turns into income in a tax setting. So you'll receive most likely a Form 1099-C at the end of the year that indicates that whatever amount of forgiven debt there was on the sale of the property is now your responsibility. When you receive that 1099-C, you want to make sure that it's reflected on your tax return. But the question arises, am I going to have to pay tax on that, call it phantom income, that you didn't actually get the benefit of? And the answer is probably not. If your taxes are prepared properly, then you should not have any tax liability associated with debt that is forgiven in a bankruptcy setting. And there are a number of ways of accomplishing this, but the most common and probably the most straightforward is to use Form 982 when you file your federal tax return. Form 982 is where you report forgiven debt that was forgiven in the context of a bankruptcy or a Title 11 case. And there's a specific election that you can make on Form 982 that addresses this. So if you're doing a short sale in a bankruptcy or as part of a bankruptcy, then that forgiven debt will not be taxable to you. And that applies not just to the property debt, but to any debt that's forgiven in a bankruptcy. So this could also apply to credit card debt, or to medical debt, or to other kinds of debt that might be discharged through a bankruptcy. Keep in mind where this comes from. The obligation to repay a debt that is then forgiven is the reason that it's treated as income when it's forgiven. And so when you discharge debts in a bankruptcy, your obligation to repay the debt goes away. And so for that reason, the IRS recognizes that treating it as income would be inaccurate. And that's reflected on Form 982. Now, if the debt that's forgiven is a primary residence, there are other ways of addressing this as well. And if it's a rental property and there's debt forgiven on the rental property, you should also look at the possibility here of actually getting a tax benefit for treating the sale of the property as a business loss or business income. So there's lots of things to consider when it comes to a short sale in a bankruptcy. But again, the summary position is that if your taxes are prepared properly, there should not be any tax liability associated with the forgiven debt from the short sale. If you have questions, please feel free to contact us about this. This is an area that's not necessarily well understood among tax professionals, but we deal with it all the time and we'd be glad to assist. So you can reach us on the numbers that are listed on this video. We hope this has been helpful and we appreciate your time.